period. And the case presents a question of law. It's a fundamental question, and that is, does the court have jurisdiction to require the trustee to account for her activities as trustee for the pre-death period?
There is no allegation in this complaint that the settlor, up until the time of her death, was incompetent or incapacitated. That wasn't part of any allegation.
That is not an allegation in the complaint.
Okay, and the breach of the other counts of the complaint with respect to transfers of money, those were post-death transfers, the ones mentioned in the complaint. So the only thing, and I don't know what happened to those. I mean, because there were several, when I looked at the complaint, it looked like there were 7 or 8 counts, and there was some for transfers in 2008 and 2009, and then there was an accountings, post-death accountings from the trustee that you wanted, and then there was the pre-death accountings.
I'm not exactly sure where to start on answer your question.
Maybe the first thing is, what happened to those other counts? What happened to the post-death and accounts
the way the case was originally filed was filed as 2 different cases. One by the estate seeking the pre-death accounting, and one by Betty as a beneficiary against the trust, seeking not only the pre-death accounting, but also alleging the damages for breaches of trust, both pre- and post-death. Does that answer your question?
Yeah. Okay, so that is, but we're only here on the estate?
The estate case was dismissed on the grounds that the estate
Maybe I didn't go far enough in the
cannot be required, that the trustee cannot be required to file an accounting in connection with the pre-death period.
Well, but okay, it was all, so you've only settled 1 count of that overall, so all the rest of them remain pending?
I believe that's correct. We had, in fact, well, there's some confusing language in the order, and it.
Well, it says the final judgment on behalf of the estate.
I believe both parties treat that as being simply relating to the estate and not to her case as a beneficiary. So the issue before the court today is, can the estate seek an accounting for the pre-death period? In fact,
I'm just thinking of our jurisdiction and I know the trust, the jurisdiction
it is a convoluted case,
yeah,
and I agree with you
yeah.
for the jurisdiction.
I'm thinking that, is this a final order on, I guess, that aspect of it?
Yeah, the case, the estate is no longer a party.
Okay. Go ahead.
So the case, the estate's case has been dismissed.
So we're only dealing with that part that's requesting the pre-death accountings. And on those claims, there's no claim that there was any breach of fiduciary duty, or that she was incapacitated in any way.
It's purely an accounting issue.
It's strictly saying we are entitled
to an accounting
for all the pre-death periods when it's revocable and when the settlor apparently didn't request them herself.
For the time period that the third-party trustee was the trustee.
Okay.
I thought there was a claim for a breach of fiduciary duty as trustee, as in addition.
Yeah. Well, what happened is we have two different cases, and Betty had dual status. First, she was a beneficiary of the revocable trust, and she was also a co-personal representative of the estate. Okay, so she filed 2 different suits. They were later consolidated into a single case with 2 different plaintiffs, one being the estate and one being her individually. The estate complaint sought the accounting. Her individual case as a beneficiary not only sought the accounting, but also alleged all the breaches.
But they were at least at this point, they are post-death breaches. The dates I saw in there were all post-death. Is there something else that maybe I looked at the wrong complaint? Maybe there was an amendment?
There was an amendment in 2014, and my recollection, I don't have it fresh in front of me right now, but my recollection is that it included pre-death a pre-death breach, and in particular it was $105,000 that was a quote over-the-counter withdrawal that we wanted an accounting as to who got the money on that.
Well, the reason I'm asking is because the cases, there are very few cases on this, and there's no case that is directly on point. I mean, there are cases like, for instance, Brundage was a case of mine, but in those cases, almost every one of them, either the requests for the accounting were made by pre-death, and then whether the state could continue with them, or they had to do with allegations of breach of fiduciary duty or incapacity of the settlor, which would mean that you would have some, when you're thinking about it, you say, well, yeah, you want to make sure that nothing while that person was incapacitated was happening, even though it was a revocable trust, even because that would be something that I think that the courts and everybody else would be concerned with. But if we've got a competent settlor to the date of death and no allegations of breach, and the settlor didn't ask for them and didn't require them, then why would we come in now and say, okay, let's go back and spend all this money to get all these accountings when it was only for the benefit of the settlor there and she didn't want them?
There is evidence of incompetence, but it's not before the court. And we never got to trial, so that any evidence with respect to incompetence
But
is
you
not
didn't
relevant.
allege that in your complaint.
Why would I allege it? The issue in the case was, you don't have, as a matter of law, the court cannot require the trustee, says it multiple times in his answer brief, cannot require the trustee to file an accounting. If you were to rule that if any court were to rule that a court lacks jurisdiction to require a trustee to account, that's an astounding ruling on its face. But that's exactly what we're dealing with. It doesn't matter whether she was incompetent or not. His position is, you don't have the authority to require her to account.
Because of the fact that type of accounting wasn't required during the life of the settlor.
Correct. And now, Judge Warner, you also wrote the Carvel opinion, and that opinion specifically said...
No, I wrote Brundage, I didn't read Carvel. I think Carvel was Judge Stone.
Okay, well, I think you concurred with it. But in that opinion, it specifically says that you have a right to account, that the estate has a right to an accounting. And
But wasn't Carvel something, if I'm not mistaken, Carvel, the demand was made prior to her death by her guardian?
Yes, there's no
And
question.
So the question is...
There's no question this fact pattern is different in the sense that what we have is a beneficiaries and the estate, the case law is clear in Florida, have the right to sue for breaches. That's undisputed. And the Carvel case says that the estate has the right to object to an accounting. So we have the estate having the right to object to an accounting and the right to sue for breaches, and then the court's going to say, but the court does not have authority to require an accounting? I mean, it just doesn't make any sense.
Let me ask you this. Let's assume you could require that. Does someone have to go back and retrace all of their steps? Because what if they weren't required to do it, and let's say the settlor lived for like 15 years, how would you go back and do that kind of an
If you
accounting?
take on the responsibility of being a trustee of a trust, you should expect that you have to account.
Even
and they
even
certainly
if the
can't
trust
have a
says
court-
you don't have to.
And, well, my client's case was dismissed on the grounds that the court cannot require the trustee to account. How could you possibly rule that?
Well, how it happened, but my question
even in the
is,
case
like,
he cites.
So my question is, let's assume we agree with you. Like, to what level is this trustee going to be required to recreate things that happened during a time when she was not necessarily, or according to the trust, required to keep that accounting? In other words, if she didn't keep track of everything that was happening, how can she go back and do that?
Well, then, I mean, she can say that, but that's in the future.
Agreed.
Okay, what we're dealing with is a situation where the case was dismissed on the grounds that the
I
court
understand.
cannot do
But
it.
we always like to ask those questions.
I
because
can
sometimes
appreciate
we
it.
have unintended consequences from things that we rule on, and so
And
that's why I'm asking.
And I appreciate what it is that you're saying, and I'm merely saying my client got thrown out of court on the grounds that the court did not have jurisdiction to order an accounting.
Is the estate a beneficiary? How was the trust set up? It didn't all go into the estate, did it?
The estate, the trust is the beneficiary of the estate, and
The trust is the beneficiary of the estate? You mean
it's called a pour over will, where the
Right,
will
right.
pours everything over to the trust.
Okay.
Okay, and the estate is a beneficiary under the Carvel opinion. It specifically says the estate is a beneficiary because the trust requires the payment of funeral expenses and things of that nature, and also if any expense, if the estate is insufficient, Florida statute requires that the trust pay the estate's bills.
Has there been any issue about that the
No, we haven't gotten that far.
Okay. We've used up all your time.
Yes, I
So,
was trying to reserve 5 minutes, but
May it please the court? Good morning, I'm Robin Blanton. I'm representing the trustee, Jennilynn Smith. This case is specifically involving the question whether or not a trustee is obligated to provide a pre-death accounting once the trust becomes irrevocable. My client became trustee 2 years before the settlor passed away. The settlor was her grandmother. The settlor maintained all of her accounts, all of her assets, her checking books. And so the trustee accommodated her grandmother by facilitating writings of checks. The settlor used her assets as her own as well she could. And the reason for that is that family members were pressuring the grandmother to forgive loans, to forgive mortgages, and the grandmother wanted some interference, and so she appointed her granddaughter as trustee of her trust. What we have here is the issue, specific issue, whether a trustee is obligated to provide a pre-death accounting for that period of time when the trust was revocable, at a time when the trust becomes irrevocable. In other words, in this case, the plaintiff, or the appellant, is seeking to require my client to provide post-death what the trust itself did not require, what the settlor did not request or demand, and what the Florida statutes do not require. And so, simply stated, my client should not be required to do post-death, that is, when the trust becomes irrevocable, what she was not required to do at a time when the trust was revocable.
Were they co-trustees? You say that
No.
the trustee let the grandmother do what she wanted with the money. She must have been able to sign checks or something like that? I mean,
The grandmother asked the granddaughter, my client, to become the trustee of the trust. And as trustee, when there would be transfers of accounts that were in the name of the trust, the grandmother would say to the granddaughter, I want to do this.
okay, so she was signing off on things.
So the granddaughter would facilitate
I see.
the grandmother using her assets as she desired. But the grandmother never requested and we're dealing with a formal fiduciary accounting. We're not dealing with a situation where there's a request for records or receipts or documents. Those have all been provided to the beneficiaries. What we're dealing with is a request or demand in the amended complaint by Betty Hilgendorf, who at that time was a co-personal representative of the estate. It was a demand in a single count, and you're right, Judge Warner, there wasn't in that count any claim of incapacity of the settlor. But it was a claim in the amended complaint that Betty had a legal right to a pre-death accounting, that my client as trustee, having not provided a pre-death accounting, breached her duty as a trustee. And so it's claim for breach of fiduciary duty as a trustee for failing to provide a pre-death accounting when the settlor didn't request it, when the trust didn't require it, and when the law doesn't demand it. For example, in this case, the trust, the applicable trust sets out the duties of the trustee. It's on page 17 of my appendix, Article 13 of the trust. The trustee shall maintain full and accurate books of accounts, records, receipts, and disbursements, ... all of which shall be available for inspection at a reasonable time by the grantor or any beneficiary of the trust. In other words, the duty of the trustee to the settlor is to keep records, receipts, disbursements available for inspection. And in this case, the grandmother herself had those transactions, had those receipts, had those bank accounts. My client didn't receive those records until after the settlor passed away. That's what the trust required of my client, the trustee, during the time the trust was revocable.
Even if that's the case, doesn't Brundage versus Bank of America support, which is a 4th DCA case from this court, doesn't that support the concept that as third-party beneficiaries after death, that they would have been entitled to pre-death accounting?
No,
if
sir.
there were any concerns about it?
So respectfully, there needs to be a distinction between a formal fiduciary accounting and a claim for mismanagement by the trustee. Brundage didn't involve a formal fiduciary accounting. It involved allegations of mismanagement and breach of trust duties for managing assets.
But didn't they provide for an accounting at that time? Wasn't an accounting requested for pre-death matters, despite the trust document not requiring it, and wasn't it granted in that case?
No, I don't think there was a... The issue was one of whether the beneficiaries had standing to contest transfers from the trust, which were not allegedly authorized by the trust or for the best interests of the settlor. And in that case, I think the trustee had issued some accountings that they wanted the court to authorize or to approve. The beneficiaries in that case didn't request pre-death accountings. They wanted the opportunity to have standing to contest them. And the court there in Brundage held that the beneficiaries had standing to dispute the management of the trust by the trustee. That wasn't an issue of pre-death formal fiduciary accountings. And so...
Right, but if they could sue to recover those pre-death matters, why wouldn't an accounting be the proper vehicle to determine what those damages were?
Well,
if there were any.
Number one, in this case, the trust doesn't require it. In fact, in this case, the applicable trust says that after the grantor's death, an accounting should be required. My client isn't saying the beneficiaries here, or that Betty here, doesn't have a right to sue for breach of fiduciary duties or breach for mismanagement. In fact, there is a separate lawsuit dealing with, you said 7 or 8 counts, and you're right, that's a separate, distinct lawsuit involving allegations of breach of fiduciary duty. That's the vehicle. And frankly, that is the distinction between a formal fiduciary accounting and a breach for mismanagement is encompassed, I believe, in Florida Statute 736.0813, which involves the duty to inform an account. Subsection D deals with a formal fiduciary accounting. In fact, there's a reference to 736.08135, which is the statute that deals with a formal fiduciary accounting. And it says that the trustee of an irrevocable trust, that is after the settlor has passed away, has a duty to provide a formal fiduciary accounting to each of the beneficiaries. But if you look at subsection E of 736.0813, it says, upon reasonable request, the trustee shall provide relevant information about assets, liabilities of the trust, and particulars relating to administration to beneficiaries. Subsection D deals with a formal fiduciary accounting, which is what the appellant in this case has requested. Subsection E deals with providing information so that there could be determination made about mismanagement or abuse or breach of fiduciary duties. There is that distinction. This case deals with a request for a pre-death formal fiduciary accounting when the trust doesn't require it. The trust only requires a formal fiduciary accounting after the death of the trustee. It says so right in subsection section 13 of the trust. The settlor didn't request during her lifetime a formal fiduciary accounting, and the Florida statutes don't require it. Florida statute 736.0603 provides, I say respectfully, a bright line standard. While a trust is revocable, the duties of the trustee are owed exclusively to the settlor. In other words, the duty for a formal fiduciary accounting is owed to the settlor exclusively while the trust is revocable. And this 736.0813 subsection 4 reincorporates or reinstates that bright line standard in subsection 4.
But aren't the other parties in the shoes of the settler? In other words, as third-party beneficiaries, aren't they sort of in the same status as the settler?
No, they are not. They are not because, number one, the trust sets them out differently, deals with them differently, and secondly, the beneficiaries don't vest in their rights to the trust assets until the trust becomes irrevocable. And then from that point on, they are entitled to formal fiduciary trust accountings. But before the trust becomes irrevocable, the duty to account is exclusively owed to the settlor. And the settlor didn't request it, the trust doesn't require it, and Florida statutes don't mandate it. And so, no, they don't stand in the same shoes. Once the settlor passes away, the trust becomes irrevocable, then the beneficiaries have a vested right to a formal fiduciary accounting. Otherwise, they do not.
Okay, thank you very much.
Thank you very much.
I'll give you a minute.
Used up all my time, but I'd like to speak.
I'll give you a minute, yeah.
The appellee has spoken about a formal accounting. The issue is whether the court can order the trustee to account. The form of the accounting is not at issue. And how that could be an issue that they raise, hey, under the circumstances, we should do it a different way, not the same way that's mandated under the statute for post-death accounting. I thought your question was well taken. Why is it that as a procedural matter, you don't have an accounting as an early stage in the proceedings? That's how trust litigation proceeds. You start with an accounting, then you find out what the trustee did, and you object to the accounting. That's where we are. We're seeking an accounting. The estate is not claiming at this stage that there were breaches because we don't have the accounting.
Thank you very much. Thank you both. Court is adjourned.
Thank you.
It's a real pleasure to see you.
Good to see you. Good to see you. Drive home safely.